All right, boys and girls, we are back with another edition of the Federalist Radio Hour. I'm your host, Ben Domenech. You can email us as always at radio@thefederalist.com. Follow us on Twitter at FDRLST. I'm happy to join you today to talk to you about a number of different cases that the Supreme Court has been considering in recent weeks, and to get the perspective of someone who we've had join us before to talk about a number of different constitutional issues and otherwise, Ilya Shapiro. Ilya, you can follow on Twitter at iShapiro. He's the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute. Ilya, thanks so much for taking the time to join me today.
Great to be here, and you can also pre-order my book, Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court, due out in September, but available on Amazon and everywhere else online where books are sold.
Wonderful. Just in terms of, I know that you gave us a very minor tease about it the last time you were on, but give us your pitch for why people should be pre-ordering it now.
Sure. Well, you want to be ready for the next time there's a vacancy. And indeed, President Trump's going to come out with a new list of Supreme Court potentials. This is going to be an issue in the election campaign. And just to understand why it's politicized, how it's politicized, what considerations politicians should be using in picking judges, and how that's all worked historically, where, you know, there's really nothing new under the sun.
Can you just give me one piece of perspective on that? It seemed to me that once President Trump, as candidate Trump, put out that list of names designed in context to reassure a lot of conservatives about what he would do with the Supreme Court, it seemed to me like that may have established a new precedent in terms of an expectation, at least within Republican primaries, that the candidate who, you know, might become president is going to have to put out some list like that going forward. Do you think that's the case?
Well, we'll see what happens the next time there's a Republican primary where Donald Trump is not running, because this was obviously a unique candidacy. And as you said, he had to reassure voters. He had to show that, you know, given his background of, you know, suggesting that his sister would be great, or being pro-choice, or various things that he said in his past, his colorful past, it was a masterstroke, showing that the people that he would select are no different than constitutional conservative Ted Cruz would have, and probably better than a Jeb Bush or a Mitt Romney. Now, it's unclear whether someone who already has conservative street cred or social conservative or legal elite street cred would have to do that in the future. But certainly, given how tight the election was in certain swing states, we know this both statistically and anecdotally through Selena Zito's work and otherwise, that list was significant.
Mm-hmm. Ilya, what have been the most significant decisions thus far in terms of the past couple of weeks?
Sure. Well, we had the application of employment discrimination law, Title VII, to sexual orientation and gender identity. Now, you know, a lot of people would think that this is a political debate we've been having the last decade or so. Should we add to the race and sex and religion and other protections in Title VII, protections for SOGI, sexual orientation and gender identity? And here, the court, by a 6-3 vote, writing through Neil Gorsuch and John Roberts, the chief, also joining the liberals on that, saying that because of sexual orientation, or because of sex, which is the statutory term, includes those SOGI categories. Controversial case. It's not a slam dunk one way or another. I've written about this, and you know, I think Justice Kavanaugh has the better of his former co-clerk Gorsuch in saying that this is being too literalist, that discriminating on the basis of sex, whether you're talking in 1964 or now, if you're saying that someone's discriminating against someone because they're gay, you generally don't say that, you know, you're discriminating based on sex, just the way that phrase works. Anyway, highly controversial. Taking that issue out of the political sphere will have broader ramifications. A few days later, John Roberts again joining with the left in blocking President Trump's rescission of DACA. This is a case in which I got some notoriety for a brief that I filed that on its cover said supporting DACA as a matter of policy and the administration as a matter of law, because if one president puts something in as an executive action, and the next president, you know, by the rule of the pen and the phone, should be able to do the same thing. But a funny thing happened on the way to that. And then this week, the John Roberts again crossing over in a significant case yesterday, the name of which I'm embarrassingly blanking on. What was the big case yesterday, Ben?
Let's see. Was it whole
That's right, the abortion
health
case, of course, the abortion.
health,
I've been talking so much about this that I'm like, well, if it's Wednesday, it must be Belgium. Who knows what's being
well, no, I
decided.
knew
But
it
anyway,
as I knew it as the Louisiana abortion
right.
case, but it's June Medical Services
June
versus
Medical
Russo.
versus Russo is the case.
Because whole women's health
thing. When you're talking about the court and the justices, you forget the
no,
abortion
whole women's
case
health,
where,
because I remember whole women's health because it's the Texas case.
Yeah.
But that's from 2016, and that's where Roberts was on the other side.
Which is the significant point. John Roberts, so the four liberals wrote an opinion. Justice Breyer wrote an opinion saying, look, this is an undue burden on the women's right to access abortion, and there's a pretext that you're having safety and health regulations. John Roberts said, no, I don't agree with that. He actually dissented 4 years ago in the whole women's health case. He said, no, I still agree that that's the wrong standard to apply, but stare decisis, the idea that sometimes you preserve precedent even when it's wrong, and this is essentially the identical case, and I will preserve it, which was an odd thing for him to say, given that this is only a 4-year-old precedent on a technical issue not very well entrenched, and on much more major cases like Citizens United, Nick versus Township of Scott, a property rights case, Janus on workers' First Amendment rights. He had no problem tossing out 40-year-old precedents and things like that. So very controversial with John Roberts. And then today we're recording this on Tuesday. The Espinoza case, where it was a more traditional, as it were, conservative over liberal 5-4 decision in favor of school choice, reversing the Montana Supreme Court in terms of a school choice program, allowing it to be to go to religious schools, not just secular ones. And there's more to be had. I mean, the Supreme, traditionally, June 30th is the end of the Supreme Court term. But this year, because the justices, like you and I, have nowhere to go, it's continuing, and who knows how long it'll go. We still are going to look at faithless electors. We're going to look at Donald Trump's tax returns, subpoenas. We're going to look at ministerial exemptions for religious organizations. So hold on to your belt buckle. It's an unusual and so far mostly bad for conservatives or libertarians for that matter kind of term.
I'm wondering about a couple of different things here. First off, the president said in our interview with him on Friday, he said the majority, it might not be the majority we think we had. And he brought up the DACA case, he brought up the census case, and he brought up the Gorsuch decision as it relates to Title VII. To me, one of the elements of this that is always kind of a black box for conservative voters is anticipating how the various potential nominees for these jobs are going to rule in the future on difficult culture war cases that often don't really get plumbed, it seems to me, outside of the issue of abortion within the hearings and the discussion that happens to them then. Was there any real sign?
Well, hearings are pretty much useless. This is one of the, I'll give you a spoiler alert from my book. I come out against, they've had a good run of about 100 years, and I think they're a net negative now for our public discourse to have these big gotcha hearings.
Interesting.
But anyway.
No, I think that will be an interesting and compelling argument. The aspect of this that I find to be, really difficult is I'm not sure that there were a lot of signs that Gorsuch was going to go in this direction. Were there that we just missed?
Well, I wouldn't see this as a betrayal by Gorsuch. He has always been a textualist. He's always been an originalist. In the Espinoza, the school choice religious liberty case today, his was the strongest concurring opinion, saying, look, we're adopting too narrow a view of religious liberty. It's not just freedom to worship in your home. It's exercising in all sorts of ways. And that's not uncharacteristic. But recall Gorsuch during his hearings was attacked for the so-called frozen trucker case, where he interpreted rather narrowly a particular OSHA, occupational health and safety regulation about operating a vehicle and leaving your vehicle and all these things. He is kind of on the literalist side of textualism, and that's where the debate was there. It's not that all of a sudden he's become I want to enforce LGBTQ rights or something like that. If Justice Ginsburg had written that opinion, he would not have joined it. He would have stuck to his textualism. So it's not so much that. The thing is, the left side of the court is much more result oriented. I did a piece for USA Today a couple of years ago comparing the block voting by the conservatives and liberals, which at this point is the Republican appointees and Democratic appointees. You kind of have that aligned. You know, the liberal bloc, the Ginsburg Four, to counteract Sheldon Whitehouse's what he calls the Roberts Five, acts much more as a unit. They have that fire discipline, if you were. Whereas on the right, you have traditionalists, you have literalist textualists, you have phraseological textualists, you have I mean, all sorts of ways to get at interpretive theories, but they're all showing scholarly integrity, except occasionally John Roberts, who makes these strategic deviations because he adheres more broadly to a philosophy of either minimalism or judicial restraint than he does to either originalism or textualism, or even his own political conservatism, I would argue. Because to be clear, John Roberts is neither a David Souter or John Paul Stevens moving left in office, nor is he an Anthony Kennedy kind of always being a moderate or a squish. Instead, he's kind of sees, you know, especially now that he is the middle seat, the median vote, sees himself as trying to depoliticize the court or preserve the court's integrity. You know, I think he's failing on his own terms in doing that, but he would rather subsume the result that he would want, either politically or in his best application of whatever legal theory he wants, to make the court look less political. But anyway, you have that dynamic discussion and debate much more among the justices on the right than on the left.
You say that Roberts is failing on his own terms when it comes to this. Tell me what that looks like and what examples you'd point to of that. Right.
So until last year, and I'll say in a moment why that's a cutoff point. Roberts had only, let's say, disappointed conservatives twice in both Obamacare cases. First in 2012, NFIB versus Sebelius, where he famously rewrote the mandate into a tax in order to preserve it. And then a few years later in King versus Burwell, where he redefined exchange established by a state to include exchanges established by the federal government in order, again, to preserve Obamacare against statutory challenge there. Other than that, he was pretty much conservative. Now, he might not have gone so far in certain cases as a Justice Scalia or a Justice Thomas would have wanted, but, you know, in Obergefell, the gay marriage case, he dissented. And many other examples, he was, you know, a minimalist, a restrained person, but certainly a conservative. Last year, and this was the first term with the so-called new Roberts Court without Anthony Kennedy on the court, John Roberts, for the first time in more than 50 years that the Chief Justice was the median vote ideologically, in the census question. He kind of took a middle tack, split the baby in a way to say that you can ask the question about citizenship, but not in this way. You didn't cross your T's or dot your I's. And you saw resonances of that in the DACA decision this year, where he said, you know, maybe you can rescind DACA, sure, but you didn't give good enough reasons. You didn't follow the proper procedures. He's trying to be a stickler. He's trying to have it every which way. But we're seeing increasingly that what he's doing is to try to defy people's expectations, to defy the narrative that, okay, we have 5 R's, 4 D's, and that's the way the court is, which is why the Democrats argue we need to pack the court because, of course, Kavanaugh and Gorsuch are illegitimate for all sorts of reasons, and therefore we just need to add 2 more appointees that President Biden would choose, and away we go. He thinks that by acting strategically or tactically as he is legitimizing the court in many people's eyes. I don't think that's right, either by the polling data in terms of people's opinions of the court, or just qualitatively speaking, are people respecting what he's doing? Not just, you know, outcome, you know, people who only look at, is this a conservative result or what have you, but elites who are looking at, is this a good way? Can this be justified? Is this really saving the court, as different Chief Justices have tried to do in the past? And so, you know, Justice Hughes, for example, during the New Deal, when he was being pressured, when FDR was promoting court packing, even before the court packing, he saw where the political winds were shifting and started shading to the left, upholding New Deal programs that he had been striking down, and eventually getting another Justice Roberts, Owen Roberts, to go along with him. Now, the conventional tale is that this is the switch in time that saved nine, that it was the pressure from the court packing that caused them to do this. I don't think that's actually the case, because court packing was tremendously unpopular and Democrats lost at the ballot box because of it. But instead, it was trying to read the political tea leaves, to mix metaphors, and not to get too far ahead or behind public opinion. And John Roberts is trying to do the same thing. And as I said, on those terms, if that is your goal, I don't think he's doing a good job with it.
Well, I feel like the takeaway that I really have as a non-lawyer from the conservatives who I talk to is they don't believe that Roberts has really any principles at all, that he's entirely outcome-based, that he views these things in entirely in politically contextual terms. And that seems to be something that is even supported by some of the people who seem to like Roberts, that basically those are his goals in mind, and they think of that as being a higher calling perhaps than sticking to his philosophy. And that example of the difference between his ruling in 2016 and his ruling in 2020 as it regards these abortion clinic admission standards would seem to fit entirely within that narrative, that he's going one way in the context of 2016 when he thinks the next president is going to be a Democrat, and he's going the opposite direction when it's a Republican who he doesn't particularly like. What do you say to that?
I think that's a fair criticism, but we have to be clear that when we're saying he's outcome determinative, this is not in terms of which policy would he like to have. Instead, he wants to achieve a result that will preserve the status quo, if you will, not create waves, leave things to the political process, to the election process, that sort of thing. And so I think there is something to that he cares about appearances and how he sees his vote as positioning the court more than either what the right policy result is from his perspective, the right legal result, or even, frankly, kind of the traditional charge against Republican appointees that have evolved or moved left, the so-called greenhouse effect, to be favored by legal or political elites and to be invited to the right cocktail parties. I think John Roberts thinks of himself more of his profession. So it's not so much any of those kind of traditional critiques, but it is that he's judging things not simply by calling the balls and strikes that he talked about at his confirmation hearing 15 years ago.
I wonder, do you believe that this is a scenario that will be looked back upon as Roberts being someone who actually did, quote unquote, save the court? Or is the pressure right now so great, it does seem greater than ever, in terms of support for either packing the court or impeaching, particularly Justice Kavanaugh, that this will be viewed as kind of a, an ultimately unsuccessful attempt to prevent the type of things that, frankly, an enormous number of the people running for the Democratic nomination for president all endorsed?
Well, look, we live in tremendously polarized times, and the Supreme Court is now part of that same miasma that the rest of our political discourse is in. So on those very controversial issues, whether it's abortion or affirmative action or voting rights or campaign finance, guns, you're going to disappoint half the people, whatever you do, or certainly half the legal elites or more. And so I don't think by triangulating or attacking left and right, he's really achieving much of anything, while the cost of doing that is losing the respect of people who are, again, correctly, in my view, and in your view, as we've been discussing, seeing this as a cynical ploy to decide cases on something other than their legal merit. So that, again, goes into my charge that he's failing on his own terms. So, I mean, obviously, we're in the eye of the storm. We're in the historical moment now. But I have a hard time believing that whether based on opinion polls or kind of subjective analyses of what the court is doing, that he's doing himself or his legacy or the Roberts court's legacy any favors by acting as he is.
One of the aspects of this that I think is impossible to anticipate is whether ultimately this is going to have a negative effect to him on his right flank. he seems to be worried mostly about the left flank and them engaging perhaps in a dramatic court-changing episode, either packing or impeachment, like I said. And I think that in doing so, he's ignoring the frustration on the right flank, which is demonstrated in slightly different and more subtle ways, but I think is having an impact, where basically I recall the arguments that would be had in the context of previous nominations, particularly around the potential nomination of Harriet Miers under the Bush presidency. The basic argument went something like, we don't really care about the judicial philosophy necessarily of a potential nominee. We only care how they'll ultimately vote on these various issues. They're just like another politician. Versus people who were saying, no, it matters a great deal. The side of their philosophy that is going to come to bear in cases, and how those cases are worked out, the precedents that they set, and the different aspects of their decisions that can be latched onto. Just putting people on the court because they're going to be a vote is not the way to pursue this, and it degrades the office in terms of our view of Supreme Court justices. My fear is that after this kind of experience with Roberts, and even in this limited way with Gorsuch, that the basic takeaway for a lot of conservatives who aren't as engaged in the judicial philosophy battles that so fascinate people like you, and to a degree me, and certainly many friends of this program, that they're just going to say, why don't we just treat this like senators, and basically just have litmus tests, have a list of things that they've got to say whether where they're going to vote on it before they get put into these jobs, make them commit to these kinds of things and not hide it behind legalistic language. Do you think that that's something to be concerned about?
Well, I don't know how this would work exactly. I mean, are the senators during the confirmation hearing, assuming we don't do away with them, they'll ask, are you going to overturn Roe versus Wade? And if the nominee says, I can't prejudge that case, then they're going to vote no against them. I have that would again be kind of a step for Republicans to have unilateral disarmament, because obviously the Democrats are going to vote against them regardless. So, yeah. Or is it maybe, or would your list be different? The thing is, like, so would you have, what would that look like? You would, I don't know, would you nominate Josh Hawley rather than anyone who's on the 20-person list that's left?
It's one way for you all to get rid of
populist people. So it's hard. I mean, there's certainly, the impact is more longer term, because already with Trump's list, with the Gorsuch and Kavanaugh nominations, the concern was no more Roberts.
Yeah.
We've managed to avoid the Souter problem, but how do we avoid this too much restraint, minimalism thing that we saw with Obamacare? So no more Roberts was the refrain. Mm-hmm. Well, even more so, no more Roberts. There's only so much farther you can go. So where the real impact is being felt is by putting wind into the sails of Adrian Vermeule, Sohrab Ahmari, kind of this common good constitutionalism, where originalism and textualism themselves are discarded, and we have kind of the right-wing equivalent of the progressive living constitutional result-oriented sort of thing, not in terms of the process of asking litmus tests, but in terms of, okay, in their history, this judge has always voted, forget whether they're consistent philosophically, but they've always voted for what we consider to be the right result. And can you measure that way, or can you argue that way? The Federalist Society in the last 20 years, it's not an overnight success. They've taught and imbued the generation, Gorsuch and Kavanaugh's generation, with an originalism and a textualism that's very different from the judicial restraint-oriented school that even John Roberts, who's not that much older, but he's 13 years older than Gorsuch, I think, mm-hmm. that his generation went through. And so will the next generation that are in law school now, that will be in law school 5 to 10 years from now, are they going to be looking at things differently and saying, okay, forget this textualism, forget this original public meaning originalism, it's mostly right, but there are too many misfires. Instead, we're just going to apply this other type of legal theory. That could happen.
Mm-hmm. One aspect of that we really have to acknowledge is that there's going to be a significant outcry as this Gorsuch decision plays out, I believe, in terms of the way that employers treat employees. The idea that Title VII was going to cover not just discrimination according to sex, but discrimination according to sexual orientation, and that would include transgender employees, is going to, I think, obviously lead to a lot of different lawsuits. And I don't know exactly how that'll play out. I don't know if there are ones already in process where this will have a significant impact.
And anytime there's an adverse employment decision, a firing, a non-promotion, or a non-hiring where the person happens to be gay, there are going to be marginally more of those kinds of lawsuits. Absolutely.
Yeah. And to me, that just is going to play out in ways that is likely to make people frustrated and make people more aware of this decision. And I think probably with some surprise, because I don't think that this is one of those aspects where I feel like the court, in terms of the transgender aspect of this, is a little bit ahead of where the country was going in terms of the arcs that the left likes to talk about. There's another aspect of this, though, that I'd like to get your take on. The overall arguments that we've seen happen thus far with this court, how do you think they would be dramatically changed with some new blood, either on the left, perhaps a replacement for Ruth Bader Ginsburg under President Biden, or with a court that pushed Justice Roberts potentially back into the minority position, where he's the chief as part of a 4 versus 5 majority? Does he suddenly go back to being conservative again?
Yes, at that point it would be 6-3. I think he would be the 6th vote for a lot of conservative outcomes, where he wouldn't necessarily be willing to be the 5th vote.
Yeah, that's something I've heard from a lot of different folks. One of the other things I've heard is that he picks his voting position fairly frequently based on who he wants to write the opinion. That they use that as there were people making that argument about his rationale in the Gorsuch opinion on that case. Do you buy that, and do you think that he does that?
Sometimes I think that is a factor. All chief justices do that. I think to a greater or lesser extent. Warren Burger, who succeeded Earl Warren, did it definitely too much. He lost respect by his strategic and calculating shifts just to indeed assign the opinion. I don't think Bostock, the Title VII case, is actually that good an example of that, because had Roberts been in dissent, Ginsburg would have been the senior justice. I'm confident she would have assigned it to Gorsuch, because if she had taken it for herself or assigned it to Sotomayor, Gorsuch might not have joined that opinion and would have written separately. That would have been the controlling opinion regardless. So that's a case where Occam's razor suggests that he just moved over to make it a 6-3 and take some of the heat off of Gorsuch, perhaps, and to make it less of a culture war type decision in a certain respect. But in general, I think there is some kind of a strategic voting on that ground as well. And by the way, he's doing this so much, not just to assign the opinions, but in general, this theme that we've been talking about, that some people have started calling this the Kagan court, because she is the smartest one on the left and very strategic, very much a people person, and perhaps is helping drive that. Maybe Robert sees her as a partner to kind of keep the court down the middle as much as possible, or be respectable, or however he wants to, however he has that in his mind.
It's amusing to me how Roberts might think that this court is down the middle. And by the way, I do think you're right when you say that you think that he thinks that way. I think from the perspective of people who don't pay a lot of attention to the court, except in the final decisions that they make. In other words, they don't care about what's in the opinions. They don't care about what's written in there. They just know the up or down on various things. I doubt that they would describe the court as in the middle. I think that they would describe it as all over the map, like that they're getting whiplash from going back and forth. That it's this pro-transgender thing on the other side, and then it's this religious school choice thing on the other side, and then it has less coherence as a court that's either trying to, let's say, maintain a traditionally cautious role to advancing the cultural debate, as opposed, being more humble as a court, hoping that people resolve that through the normal representative political process. The court now is in this position where it basically acts as the one functioning branch of government, but it does so in ways that are outsized in terms of its impact on American life. And I think that's something that's a view shared by both right and left. Is there any hope of getting to a point where the court doesn't have this kind of sway over the way that we live, the way that businesses work, the way that decisions are made about these very divisive cultural elements of our society?
I recommend the last chapter and conclusion of my book that addresses that precise question. I mean, look, what we're seeing is the culmination of several trends whereby we have divergent interpretive theories on both statutory and constitutional interpretation that map onto partisan preferences at a time when the parties are more ideologically sorted than, I don't know, the Civil War. And, you know, that could change as we live through our populist moment, and maybe there's going to be some reorganization. But for now, that's where we are. And so there's no, it's a zero-sum game. There are only so many seats. These things matter. For various reasons, the court is called upon to decide, and even with issues that don't get to the Supreme Court, the lower federal courts decide all of the biggest controversies in American political life. And it's not supposed to be that way. If they're deciding those political controversies, then obviously this is going to be fraught. So the ultimate solution is to take away power from the court and the judiciary, not by kind of stripping jurisdiction, but by having the court itself enforce federalism and the separation of powers. That is, force Congress to make those tough political choices rather than passing the buck to the executive branch, to the administrative agencies. This is part of Ben Sasse's opening remarks at Justice Kavanaugh's confirmation hearings, because you can't unelect bureaucrats, you can only sue them. And so all of these big issues on the administrative executive branch side end up in the courts and in the Supreme Court. Similarly, on the federalism side, the court over decades, this is not something new with John Roberts or Anthony Kennedy or you know, anything modern, for decades has allowed more concentration of power in Washington, in a large pluralistic country. And so, you know, we don't need to have a one-size-fits-all healthcare regulation in this country any more than we need zoning rules to be the same in Houston and New York and Chicago and what have you. And so only by enforcing the Constitution's structural protections and thereby devolving power both within Washington and away from Washington will these decisions become less controversial. And then where will the controversies be? Back in Congress, back in the state legislatures, where we're supposed to hash out our cultural and policy differences.
It's still amazing to me that the court botched their Obamacare decisions as much as they did. And when I say botch, it's not limited to them going in a direction that I didn't like. It was in them thinking certain things about the decisions they were making that clearly were wrong, and that any healthcare policy person worth their salt would have told them they were wrong. They clearly thought that they were engaging in something that would defend and protect against disruption for a major part of this legislation, while at the same time, by a 7-2 majority, finding against the one aspect of Obamacare that was probably the most predictable, not certainly something I favored, but something that was, recognizable and ended up signing up far more people than expected, and that was the Medicaid expansion. So in terms of what they did there, it was kind of a worst of both worlds scenario. It's like you're throwing the wrench into this, you're redefining these things, you're rewriting the statute, and you come out at the end with a healthcare system that's way more of a mess. You know what I mean? It's and this is the best functioning, and this is the best functioning branch of government.
Absolutely. They could have just expanded Medicaid. They could have created government exchanges for high-risk populations that otherwise aren't being covered. They could have done a whole lot of things without messing with, the private healthcare market. I mean, the private healthcare market has its problems too, because it shouldn't be tied to the employer, and there's all these, perversions and what have you. But look, we're still litigating this. The court this fall is going to hear the latest challenge to Obamacare, and I'm filing my brief on Thursday. and recommending that if you like your plan, you can keep your plan, but people in the individual market should boost their premiums in a way that they don't want. Yes, you're right. The court botched it all over the place, and namely, especially John Roberts botched it all over the place because he thought he was splitting the baby and letting the 2012 election decide ultimately Obamacare's fate. It hasn't exactly, become less controversial since then. So you're right. Again, this is why we don't want judges acting as junior varsity politicians and trying to make these kinds of calls. Look, if NFIB in 2012 had been a 5-4 decision with Anthony Kennedy joining the liberals to say there are no limits on federal power. Yes, you can regulate the most local thing. That would have been taken with more clarity than what Roberts did. That would have been just like, okay, this crazy left-wing view that the Constitution imposes no limits on federal power, let's vote on that. I mean, we can understand that view. It's wrong. What Roberts did is like, what are they doing up there? We don't understand what kind of, Congress is supposed to be writing these compromises, not the court rewriting everything. And so, I think he's doing, by playing what some people say is the long game. I think we're going to be dead before this game is over. But anyway, he's hurting the country more than just letting the political chips fall where they may.
Let me go out on this. We hear a lot about the success that President Trump has had in terms of getting people nominated and into the judiciary under
no circuit court vacancies for the first time in over 40 years. I mean, remarkable. 53 appellate judges in 3.5 years, where Obama had 55 in 8 years. I mean, great success there. Absolutely.
What is the general nature of these judges? And granted, this is early, but I'm curious as to your perspective on if they tend in a certain direction or if they, tend to be one way or the other in terms of their ideological affinity. We hear a lot about the judges and the numbers, but we don't necessarily know who they are yet.
So to make a generalization, they are originalists and textualists, and they present a lot of intellectual horsepower. On both of those measures, this administration has done much better than George W. Bush or, Reagan had a lot of superstars, but there were a lot of kind of middling judges as well, because the bench just wasn't as big as it is now with the transformations that we've had. And so, again, as the general rule, I'm not, you can pick out exceptions, but certainly on the circuit bench, which is picked differently, it's picked much more by the White House counsel's office and the Justice Department, whereas district judges are compromises with senators and all sorts of things like that. But the circuit nominees, those 53 judges I mentioned, the ratio of solid movement, originalists, textualists, conservatives, libertarians, however you want to describe it, to establishmentarian hacks is exceedingly high. I think it's the biggest triumph of the administration, to be frank. Mm-hmm. So, and Mitch McConnell bears a lot of credit of that. White House counsel's office, especially Don McGahn, was laser focused on doing that. And we're seeing that already. They're young, they're eager, they're writing opinions that are solid across the board, whether we're talking about pushing back on the administrative state, whether we're talking about the Second Amendment, campaign finance, religious liberty, anything that you're broadly talking about theoretically or in terms of policy. Again, as a general rule, they're very strong on.
Mm-hmm. I'll be curious to see the kind of impact they'll have in coming years, because I think, as you know, my own opinion is that all the people who say that the culture war is just going to go into neutral and everything's going to go back to normalcy in the wake of a Biden election in the fall, if that happens, I think that they are incredibly naive.
Yeah, I think a lot of libertarians especially try to ignore the culture war and think it's not about them, but you might not be interested in it, but it's interested in you. And I think I fear what I've been seeing the last few months in the culture, in the country. I don't know whether this is a failure of our government school system, teaching at best the Howard Zinn theory of history.
At best.
But I mean, when I was growing up as a double immigrant, I came over from Russia to Canada and kind of was an autodidact in terms of American history and civics and all this, life, liberty, and pursuit of happiness and these ideals that we don't always achieve, but what we're grounded in, a man's last best hope for freedom in the world, we're not living that. I really, I'm preternaturally an optimist, but I really fear what I'm seeing.
Mm-hmm. I think that a lot of people are with you on that, Ilya, and we have to hope that there are many strong folks out there who, like you, are willing to stand against this tide and not be intimidated by it. So thank you so much, Ilya Shapiro, for taking the time to join me today. I really appreciate
Always
it.
Happy to be in the arena, always anxious for the fray.
And give us the title of your book again so folks can go out and pre-order it.
Supreme Disorder, Judicial Nominations in the Politics of America's Highest Court.
Great. Thank you, Ilya. I'm Ben Domenech. You've been listening to another edition of the Federalist Radio Hour. We'll be back soon with more. Until then, be lovers of freedom and anxious for the fray.